Good evening friends, I welcome you all again to my audio tutorial. In this audio tutorial, I will tell you about the citizenship part 2 of our Indian Constitution. Now part 2 of our Indian Constitution is covered from Article 5 to Article 11. In this, all the matters related to citizenship of India are being told in detail. Now starting this clip, I will like to tell you in brief what these articles 5 to 11 say in short form, and after that I will brief about them. Article 5 of the Indian Constitution tells about the citizenship at the commencement of the Constitution. Article 6 of the Indian Constitution tells about rights of citizenship of certain persons who have migrated to India from Pakistan. Article 7 of the Indian Constitution tells us about rights of citizenship of certain migrants to Pakistan. Article 8 of the Indian Constitution tells about rights of citizenship of certain persons of Indian origin residing outside India. Article 9 of the Indian Constitution tells us about persons voluntarily acquiring citizenship of a foreign state not to be citizens of India anymore. Article 10 of the Indian Constitution tells us about the continuance of the rights of citizenship. Article 11 of the Indian Constitution tells us about the power of the Parliament to regulate the right of citizenship by law. So, coming back to Article 5 of the Indian Constitution, Article 5 of the Indian Constitution, first of all, I will read the legal language and then I will explain it to you. Article 5 of the Indian Constitution says that at the commencement of this Constitution, every person who has his domicile in the territory of India and point A, who was born in the territory of India, point B, either of whose parents was born in the territory of India, or part C, who has been ordinarily resident in the territory of India for not less than 5 years immediately preceding such commencement, shall be a citizen of India. This means that our Constitution commenced on 26th January 1950. We all know about it. Now, each and every person who has been residing in India from 26th January 1945 or before it would automatically be a citizen of India. That means a person who either was born in the territory of India or either of whose parents were born in the territory of India or who has been resident in India from 26th January 1945 or before that date would automatically be a citizen of India. This is what is being basically told in Article 5 of the Indian Constitution. So it is not difficult to infer here that even if a Portuguese citizen who has been resident in India from or before 26 January 1945 will automatically become a citizen of India on 26 January 1950. So, this Article 5 of the Indian Constitution deals with those persons who have been resident in India at least for 5 years before the commencement of the Constitution, that is from 5 years before 26 January 1950, that is on or before 26 January 1945. But this Article 5 of the Indian Constitution only deals with those persons who have been resident in India from or before 26 January 1945. In order to know of the rights of persons who came to India after 1947, it has been covered in Article 6. Now first I will read Article 6, then I will tell you what Article 6 is. Article 6 says, notwithstanding anything in Article 5, a person who has migrated to the territory of India from the territory now included in Pakistan shall be deemed to be a citizen of India at the commencement of this Constitution if Clause A, he or either of his parents or any of his grandparents was born in India as defined in the Government of India Act 1935 as originally enacted. Clause B, point 1. In case where such person has so migrated before the 19th day of July 1948, he has been ordinarily resident in the territory of India since the date of his migration. Clause B, part 2. In the case where such person has so migrated on or after the 19th day of July 1948, he has been registered as a citizen of India by an officer appointed in that behalf by the government of the Dominion of India on an application made by him therefore to such officer before the commencement of this constitution in the form and manner prescribed by that government. Provided that no person shall be registered unless he has been resident in the territory of India for at least 6 months immediately preceding the date of his application. Now, this is the total legal document which has been written in Article 6 of the Indian Constitution. I know that just listening to it or reading to it cannot explain us the detailed meaning of this Article 6 of Indian Constitution. Now, I will explain this Article 6 of Indian Constitution to you in detail. The very first clause of the Article 6 of the Indian Constitution says that if a person who has born in India or either of his parents has born in India or either of his grandparents has born in India, and in that India which was defined in the Government of India Act of 1935, the India that was being defined in the Government of India Act of 1935 was undivided India. That means that it also included the Indian subcontinent and also the Pakistani part. That means any person who is born in undivided India, or his parents are born or his grandparents are born, he would become a citizen of India at the commencement of this constitution. This is what clause A of Article 6 tells us. Clause B of Article 6, first part. Now, the first part of Clause B of Article 6 deals with those persons who have migrated to India before 19th day of July 1948, and he has been ordinarily resident in the territory of India since the date of his migration. Now, the point is that all those persons who have migrated to India before 19th July 1948 and he has been resident in India from that date will automatically become a citizen of India. Clause B of Article 6, second part says that all such persons who have migrated to India after 19th July 1948, in order for him to become a citizen of India, he should be registered as a citizen of India by an officer that was appointed in that behalf by the government of the Dominion of India, or basically the government of India. Now, this is basically the permit system that was being formed at that time by the government of India, which allowed persons who were coming back from Pakistan to India in order to have a desire to permanently reside in India. But there was a small limitation in this clause B, second part of the Article 6 of Indian Constitution. This limitation was that all those persons who have migrated to India after 19th July 1948, before making an application to register themselves as the citizen of India, they should have resided in India for at least 6 months before making such an application. This condition was not present for those persons who have migrated to India before 19th July 1948. But all those persons who have migrated to India after 19th July 1948, in order to get themselves registered as a citizen of India, they should have resided in India for at least 6 months prior to their registration for being a citizen of India being made. So this is Article 6 of the Indian Constitution. Coming to Article 7 of the Indian Constitution. Article 7 of the Indian Constitution, first I will read the legal language, then I will tell you in detail what this Article 7 of the Indian Constitution says. The legal document says that, notwithstanding anything in Articles 5 and 6, a person who has after the first day of March 1947 migrated from the territory of India to the territory now included in Pakistan shall not be deemed to be a citizen of India. And provided that nothing in this article shall apply to a person who, after having so migrated to the territory now included in Pakistan, has returned to the territory of India under a permit for resettlement or permanent return issued by or under the authority of any law, and every such person shall, for the purpose of clause B of Article 6, be deemed to have migrated to the territory of India after the 19th day of July 1948. Again, this legal document is a bit difficult. I will explain it to you in detail. Article 7 of the Indian Constitution simply says that all those persons who have migrated from India, from the territory of India to the territory of Pakistan after 1st March 1947 will not be considered as Indian citizen. But all those persons who have migrated back to India from Pakistan under the permit system that was being initiated by the government of the Dominion of India, in which, as I have already told you in clause B, second point of Article 6, that through this clause, if any person who is coming back to India after July 1948 can get himself registered as a citizen of India if he is making his application before residing in India, after residing in India for at least 6 months. So the limitation of Article 7, that any person who has migrated to Pakistan after 1 March 1947 will not be considered to be an Indian citizen, but if he has returned back to India after 19th July 1948 and had made his registration under the permit system that was being initiated at that time, he will automatically be considered as an Indian citizen after being given the registration of being a citizen of India by an officer who was appointed on the behalf of the government of Dominion of India. This is simply this. That means that Article 7, which debars citizens who have migrated to Pakistan from being a citizen of India, this article doesn't stop people who were returning back to India from Pakistan after July 19, 1948 under the permit system that was being initiated at that time by the government of Dominion of India. So this was Article 7. Coming back to Article 8, moving forward to Article 8, sorry, not coming back, moving forward. Moving forward to Article 8 of the Indian Constitution. First I will read it, then I will explain it. Article 8 of the Indian Constitution says that, notwithstanding anything in Article 5, any person who or either of his parents or any of whose grandparents was born in India as defined in the Government of India Act 1935 as originally enacted, and who is ordinarily residing in any country outside India as so defined, shall be deemed to be a citizen of India if he has been registered as a citizen of India by the diplomatic or consular representative of India in the country where he is for the time being residing on an application made by him, therefore to such diplomatic or consular representative, whether before or after the commencement of the Constitution, in the form and manner prescribed by the government of the Dominion of India or the Government of India. Again, this is very difficult. I will explain it to you in a very easy language. This Article 8 of the Indian Constitution says that any person who was born in India, or his parents were born in India, or any of his grandparents were born in India, according to the Government of India Act of 1935. That is, the India that was being defined in the Government of India Act 1935 was undivided India. That means it also included the parts of Pakistan. Now, any such individual who was born in India, or any of his parents were born in India, or any of his grandparents were born in India, if for that time he is not living in India and he is living in a foreign country, and he wants to come back to reside in India, then he has to make an application for being registering himself as a citizen of India to the consular or diplomatic representative of the India in that country in which he is residing right now. Suppose any person whose parents were born in India, but he was living in Australia, and in the Indian Embassy of Australia, he made an application that he wants to become a citizen of India, and that consular representative of India registers him as the citizen of India. Now, through his registration, that citizen who was residing in Australia will become a citizen of India. And this can happen even before the commencement of the Constitution of India and also after the commencement of the Constitution of India. That means that provisions were made for those people who at the time of partition of India or at the time of freedom of India were not living in India. Provisions were also made for them. Moving forward to Article 9 of the Indian Constitution. Article 9 of the Indian Constitution simply says that persons voluntarily acquiring citizenship of a foreign state will not be considered as citizens of India. The legal language says that no person shall be a citizen of India by virtue of Article 5 or be deemed to be a citizen of India by virtue of Article 6 or Article 8 if he has voluntarily acquired the citizenship of any foreign state. That means that if you voluntarily acquire a citizenship of a foreign country, your citizenship of India will be automatically cancelled. So after completing Article 9 of the Indian Constitution, coming to Article 10 of the Indian Constitution. Article 10 of the Indian Constitution simply tells us about the continuance of the rights of a citizenship. That means that from Article 5 to 9, I have told you about many ways through which persons have acquired the citizenship of India. Now this Article 10 of the Indian Constitution says that every person who is or is deemed to be a citizen of India under any of the foregoing provisions of this part shall, subject to the provisions of any law that may be made by Parliament, continue to be such citizen. That means that by using the powers that has been conferred upon citizens or upon individuals to acquire citizenship of India from in Article 5 to Article 9, all those persons who have acquired their citizenship through these Article 5 to Article 9, they will remain citizen of India, subject to the provisions of any law that may be made by the Parliament in future. That means if you have a citizen of India, you will continue to remain the citizen of India until and unless it is being abrogated or terminated by any law that is made by the Indian Parliament. Coming to Article 11 of the Indian Constitution. Article 11 of the Indian Constitution deals with the power of Parliament to regulate the right of citizenship by law. It says that nothing in the foregoing provisions of this part shall derogate from the power of Parliament to make any provision with respect to the acquisition and termination of citizenship and all other matters relating to citizenship. This means that Article 10 says that you have the right to continue your citizenship, but the Parliament is supreme in making any law regarding the citizenship of India. That means that at any point of time in future or present, Parliament can make laws related to citizenship, and if those laws contain any provision that can abrogate or derogate the citizenship of any individual, then he will not be allowed to be a citizen of India. That means that the Parliament has the power to make laws related to citizenship, and those laws can be in favor of anyone or they can also be against of anyone. This means that the parliament has the supreme power to make laws when it comes to the subject of citizenship. Good evening, friends.